When you spend enough time in the world of trust law, you start to recognize something. Language carries history, and Cestui, as old as it sounds, still shapes the foundation of modern American trust law. Today, I'm walking you through what it really means, where it came from, and what the courts have actually said. This won't be theory. This will be grounded, reflective, and precise. Let's begin at the heart of it. A Cestui trust is simply the beneficiary of a trust, the person for whose benefit property is held. In spite of the name, it is not a trust in and of itself. And yes, this concept is fully recognized in American law, not as folklore, not as internet mythology, but as a core part of equity, inherited directly from English common law. The Supreme Court reminds us of this heritage in Mapp v. Ohio, noting that the framers were profoundly aware of the English common law and equity traditions. 367 U.S. 643, 650, 1961. In other words, the trust system we use today is built from the same soil where Cestui trust first grew. U.S. courts have used the term directly and without hesitation. In Boger v. Jones, 143 U.S. 207, the court held that the Cestui trust is entitled to enforce performance of the trust according to its terms. In Graham v. Railroad Commerce, 102 U.S. 148, the court affirmed that a beneficiary may proceed in equity to compel the trustee to act. And in Magel v. Supreme Council, 81 F. Sabrad 1, the Ninth Circuit described the Cestui trust as the party beneficially interested. These aren't footnotes in history. These are the pillars of modern trust doctrine. To understand where this came from, you have to go back centuries back. Trust law began as a workaround. Medieval landowners conveyed property to the use of another because the common law was rigid and equity had to evolve to deliver fairness. These uses are discussed in Tyrrel's case, 1557, then recognized more fully in Burgess v. Wheate, 1759, a foundational ruling acknowledging the beneficiary's equitable claim, and later clarified in Saunders v. Vautier, 1841, which established that an adult beneficiary could even terminate the trust. That line of cases, that historical arc, is the path that leads directly to us. When America adopted English common law, we adopted the trust structure wholesale. The terminology changed. The underlying rights did not. Even modern cases, like Lewis v. Anderson, 615 F2D 778, affirm that equity protects the beneficiary's interest, a direct descendant of the Cestui trust doctrine. Now, because clarity matters, let's address what the doctrine doesn't do. Courts have repeatedly rejected arguments about alleged secret trusts tied to birth certificates, strawman entities, or all-caps name theories. These ideas collapse under scrutiny. In United States v. Banabi, 654 F3D 753, the Seventh Circuit called these theories frivolous and nonsensical. In Bryant v. Washington Mutual Bank, 524 F. Sud 753, the court rejected claims that birth certificates create trusts or accounts. And in United States v. Mitchell, 405 F. Sup 2D 602, the court dismissed attempts to separate oneself from a so-called legal fiction. The Cestui trust is real, but it applies to actual trusts, with real property, real trustees, real terms, not metaphysical constructs, not hidden accounts, not redemption theories. So here's the truth, clear, steady, unembellished. The Cestui trust is valid. It has deep historical roots in English equity. U.S. courts continue to recognize it today, and they guard it against misuse. When you understand the doctrine in its authentic form, you see it for what it is, a cornerstone of trust law, and a reminder that equity has always existed to protect the one who benefits.